Good morning. Happy Tuesday. Looks like we all weathered the storm of Earl. Earl had posted in Bunny Boots Discord that a storm is coming Monday, and Earl is the storm. I don't give a lot of credence to anything that Earl says because Earl's a fucking liar. He's a congenital liar. He can't help but lie. He's a compulsive liar. He was hunting Nazis down in South America, don't you know? He's a liar. Anyway, I've been pondering what the hell could Earl have meant? Because Earl's going to try to have something, right? You know, he was in federal law enforcement. Wink. That means for a year or two, probably a year, he was an MP before he got busted down to security guard. He has permission signed by the governor of Texas to carry a black powder firearm, or to carry his weapon, I should say, before we realized it was a black powder firearm. And presumably that permission is a statute that defines firearm as not being a black powder firearm. You know, there's always a grain of something in there, but it's so distorted and it's just indistinct. It's just unrecognizable truth. You're not in federal law enforcement if you're an MP. For fuck's sake. I wonder if he took a trip, like a vacation to Argentina one year or something. Or maybe he went to a city in Texas or a town in Texas called Argentina, Texas or something. And that's what he's basing his hunting Nazis or what, I don't know. So anyway, I was trying to figure out what the grain of truth in his "the storm's coming Monday" lie was. It can only be, at least all I can assume, is that he submitted lie detector results, or that he has lie detector results. His further claim is that he has submitted them to the grand jury. That's a lie. He did not. He didn't submit them to his attorney. That's for fucking sure. Because his attorney wouldn't let that shit go. His attorney would tell him to stop fucking talking. Here's the fun thing about statements made out of court. And yes, statements made to a lie detector examiner are statements made out of court. They're hearsay. And hearsay, a statement made by a party opponent, can be used against that party. But they can't be used for that party. Anything you say can and will be used against you in a court of law. But only things you say in court can be used for you. We have a bunch of junior lie detector examiners poring over the results, trying to figure out if he worded it in such a way that he could pass. Who really cares how he could pass? Lie detectors, they detect your physical responses. And some people have certain physical responses when they lie. Other people lie all the time. If Earl's lying on his baselines, then he's going to show his not lying everywhere. And Earl lies all the time. There is a reason, if you Google how to beat a lie detector, you can see that it is fucking ridiculously easy and well known how to beat lie detectors. Lie detectors are inadmissible in court. They are also hearsay. And if you are trying to use, good morning, if you're trying to use a lie detector examiner as an expert witness, well, you'd have to be there, subject to cross-examination. And even then, I don't think that you can get the lie detector results in. You can't substitute a lie detector for a jury. The jury determines who the liar is. That's the jury's role. They are the determiner of fact. So no, he didn't submit it to the grand jury. He can't submit it to the grand jury. The prosecuting attorney determines what goes in front of that grand jury. The grand jury hearing is not a trial, it's a hearing. It's an ex parte hearing. It means that just the prosecuting attorney is there. That's it. He may subpoena the proposed defendant to be a witness, in which case the defendant would have to come and give testimony. But the defendant, for lack of a better term, doesn't have counsel in there. The witnesses aren't subject to cross-examination. It is a hearing to determine if there is probable cause. And probable cause is a very low standard of proof. If you were looking at percentages, and this is just a first year family law attorney's bullshit interpretation of all of this, so take this with a grain of salt. Beyond a reasonable doubt would be somewhere in the 90+ range, percent certainty. Clear and convincing evidence, you'd be up in like the 75% range. Preponderance of the evidence, you'd be 51+%. And then all the way down where nothing really happens except for indictments and informations, you have probable cause. I would put that somewhere in the 30% range. They're just saying, yeah, it's reasonable to believe, based on these facts, that a crime was committed and that person X committed that crime. It's reasonable to believe that. And then, just possibility is way down 1% and up. Possibility isn't a standard of proof, though. It isn't a burden of proof. So I wouldn't even worry about that. Is it possible that it'll rain today in the Sahara? Sure. Is it probable? No. Anyway, so I think that was the tempest in a teacup that Earl was promising. If anybody's curious, no, I was not served by anybody. To the best of my knowledge, I've had no complaints made against me to the state bar. If there have been any complaints made against me, the state bar has not contacted me on them. The call flood is or isn't non-existent. I don't know, but it certainly hasn't affected me. So, I don't know. There have been like 20 negative reviews placed on the Google site, the Google reviews of where people think I work. Okay. Ooh. People who were never clients, who are unsatisfied with the work of that particular law firm. I'm sure that everybody is going to really appreciate that. Anyway, long story short is that once again, does anybody remember the Pineville case? I think it's Pineville, Louisiana. Something along those lines. Pineville, Pinecrest, Pinecone, Pineapple. Earl was arrested out in front of the National Guard in Pineville. I'm going to call it Pineville even if it's not. By some Gomer Pyle motherfucker who did in fact violate his rights. Earl didn't want to spend the money on an attorney to fight it because it was a piddly ass charge. And because the town's corrupt, the municipality's corrupt, right? He knows this ahead of time because Earl's a fucking legal expert. So he loses the case, but he has his expert, and I'm using huge air quotes around expert, submit a his unnamed expert submit a letter to the court explaining how in the expert's opinion Earl isn't guilty or some dumb shit. It's completely retarded. Completely retarded. Anyway, and Earl's explanation for submitting that letter, even though it would be hearsay and inadmissible, and if you are going to submit anything from an expert, then you have to have that expert available to testify and be cross-examined, blah, blah, blah. There's also, the Daubert rule, or there's another rule, tapes, tested, accepted, peer-reviewed. I don't remember the rest of the acronym. I'd have to look it up. I don't mess around with experts too often, except in medical malpractice and legal malpractice, and we don't get into a lot of these rules. Come on. She's not interesting. Come on. Cyclops running with the headlight. Dog's like, what the hell, man? It's got a bright eye. It's the anti-dog. Anyway. Yeah, so that whole Pineville thing, that was just a huge clusterfuck. I wonder if anybody knows what ever happened, because he appealed, in quotes, appealed it to the next court up, and he actually hired an attorney. So basically he pissed away his lower court chance of winning, and then he had to hire an attorney for his next level up, whatever the hell that is, in Louisiana chance to win. And anyway, I wonder whatever happened with that. And I wonder, now that he has an attorney, or at least presumably had an attorney, I wonder if his attorney submitted that expert, in quotes, testimony. I'll bet his attorney didn't. Because again, it's hearsay. And there's no cross-examination of that expert, in huge air quotes, expert. So yeah, lots of problems. Lots of problems. That's what happens when you have someone as dumb as Earl thinking they're smart and thinking that they're going to send lie detector results. They're going to pay for their own lie detector tests. They're going to handpick their own questions. They're going to handpick their own examiner. And then they're going to submit those to the grand jury. That's just retarded. Anyway, I guess that's really it. Thanks for watching. I'm sorry we're not having a useful discussion on the First Amendment today, but whatever. Have a great day.